Representative Wintrow. At long last, you get your hearing. Welcome to the committee.
Thank you, Mr. Chair, and thank you, committee members. I'll hope to keep this succinct. Hopefully my people are still here that are going to present. So I'll wait till everybody gets kind of settled. Thank you for the opportunity to present House Bill 528. It's been a product of collaboration between victims advocates, law enforcement, prosecutor's office, Idaho State Police, the Idaho State Forensics Laboratory. I even consulted with the Attorney General's office to make sure I had language correct and take his ideas into account. And it does have the support of the Police Chiefs Association. I've received no known opposition to this point about this bill. I did have some questions raised in committee that were addressed, which I'll share in a minute, but thankfully those were addressed and hopefully to the committee's satisfaction. So today I'm going to provide you an overview of what the bill does and doesn't do and why it's important. And then I'm going to yield a little bit of time to Jennifer Landis, who will provide a broad view of sexual violence in our state. She works at the Idaho Coalition Against Sexual and Domestic Violence. And Cynthia Cook, who is a sexual assault she is a sexual assault nurse examiner, will actually give you a better idea of what goes on in a forensics examination, because I think that's important with the bill that we're looking at. And then Matthew Gamet will speak, and he is the director of the Idaho State Police Forensics Laboratory. And since this bill is really about a process to collect DNA, it's important to hear his testimony. And then I do have the prosecutor, Ada County prosecutor from their office, Gene Fisher, is here to answer any questions. I did have some police, but I don't know, they might have had to go to another committee, so hopefully you won't have any questions for them. So with that, briefly, why is this bill important? As I said before in the introductory hearing, it's important because with DNA testing, when kits are tested, we can identify an unknown assailant in the case of a rape. We could confirm the presence of a known suspect. We could affirm the survivor's account of an attack and potentially discredit a suspect, or we can connect the suspect to other crimes or exonerate somebody that didn't do the crime, as we've heard today in other cases. Rape kit testing sends a message to survivors that their voice matters, and we're going to take this seriously. And it also sends a message to perpetrators that, again, we're going to take this seriously and they will be held accountable if convicted. And it demonstrates that commitment to survivors and I think potential perpetrators. So what does this bill do? It creates a minimum standard for rape kit testing in our state and provides a reasonable time for that processing. It establishes a tracking system to improve efficiency and transparency, and it requires an annual report to the legislature to provide us with a continuing view of how the system is running. Currently, with no statute in place, there is room for inconsistent approaches that could impact efficiency and service. Somebody recently, kind of leaned over and said to me, if you don't have rules in place, how do we know what to follow? And that's true. If we don't have good, consistent methods to inform our state law enforcement agents, it's difficult for them to provide a consistent service around the state. So I think this is a real good support for law enforcement as well. Matthew Gamet, who will talk a little bit, has been working very hard to create an interdisciplinary team to respond to this issue. And I actually attended one of those meetings this fall. And the main question that I heard that many of the people were discussing was which kits should we process and how? And initially when I heard that, I was a little troubled, but there are some complexities to that question that go into prosecution, investigation, as well as victims reporting. So it's not as easy as I once thought, and actually retracted from some of my initial thoughts about that. So in that question then, which ones should we process and how? This bill clarifies and codifies which kits to test and in what reasonable timeline to do it in. This bill will support victims, law enforcement, healthcare providers, prosecutors, and other criminal justice personnel because they will be operating from the same set of rules and the same playbook. It clears up misunderstandings and provides a clear protocol to improve our service to victims. So which kits will be tested? They'll all be tested unless a victim expressly says not to, which is very common in our sexual assault laws, or there's no evidence of a crime being committed. How long will it take? The timeline we have set aside is 30 days to get the kit to ISP, and then ISP will have a 90-day process or a turnaround to enter the data in the CODIS database, which you'll hear more about. And Representative Luker was good in reminding us in the initial language, what if somebody doesn't meet that deadline? We don't want to penalize a case in prosecution or inhibit speedy trial, so we did add language, and that was reviewed by the prosecutors and ISP to make sure we got that in a good spot. So thank you for that. If the kit isn't turned in for processing at all, this bill then indicates that law enforcement will consult with the county prosecutor, and the county prosecutor will sign off. And that's not a real cumbersome or laborious process because law enforcement is really communicating with their county prosecutor anyway. This puts one more set of eyes to be sure, hey, we don't need to test it, or should we? And then tracking. The ISP will be promulgating rules to devise the best tracking system, and then they'll be responsible for checking back with the legislature and providing that data for the public. I'm going to let Matthew talk a little bit more about the fiscal note, because I do think that's important. We do, if we are actually going to hold criminals accountable, we have to have good systems in operation. We have to fund them appropriately. And if we don't want to get into a situation where we have a large backlog or people are criticizing our state, we have to have the resources to support law enforcement, prosecutors, and victims to make sure that's happening. As well as we know, again, it could exonerate somebody if necessary. With that, I'd yield some time to Jennifer, who's going to tell you a little bit about the big picture of sexual violence in our state, and then she'll yield time to Cynthia, who is that SANE nurse, and then Matthew Gamet will finish up with information about the forensics lab, and then I can come back and answer any other questions.
Welcome to committee, ma'am.
Thank you, Chairman Wells.
State your name for the record, if you would, please.
Jennifer Landheis, Landheis. My name is Jennifer Landheis, and I am the Director of Social Change at the Idaho Coalition Against Sexual and Domestic Violence, and I've been an advocate on the behalf of victims of sexual assault for the last 20 years. As a statewide coalition comprised of 23 programs that are providing direct services to victims, we are here in support of House Bill 528. The Idaho Coalition Against Sexual and Domestic Violence was one of several key stakeholders that were involved and collaborated together in this process to address the gaps and shortcomings in Idaho's current processing of rape kits. This has been truly a multidisciplinary effort, and we are thankful for Representative Wintrow's endeavors on behalf of victims of sexual assault. Every 2 minutes in the United States, someone is raped. That translates, since you started your committee this afternoon, 45 individuals across the U.S. While there's been a lot of concern about the levels of false reports of sexual assault, both the FBI and the United States Department of Justice estimate that level is only 8%, no higher than any other crime. But rape is a crime for which all too often the only one who pays the price is the victim. We know, according to the Bureau of Justice Statistics, that only 30% of victims report their rape to law enforcement. Victims don't report for a variety of reasons: fear of the perpetrator, fear that they won't be believed, fear of being re-traumatized by the system, and fear that if they do come forward, that nothing will happen. Those are all legitimate concerns. And so when a victim does come forward and time has elapsed, depending on the time that has elapsed since the sexual assault, they are asked to participate in a sexual assault forensic exam. What you'll hear today, evidence is collected in what we call a rape kit. While my colleague Cynthia Cook, a SANE nurse, will explain to you exactly what a rape kit is, I encourage you to look beyond the cardboard box that contains the evidence. Each kit, in actuality, represents a human being, somebody who endured a victim who endured a crime that nobody deserves to endure, a victim who then endured a medical process that's long and arduous to collect that evidence, and a victim who deserves to have that kit tested. While an invasive process for the survivor and the victim, the potential benefits from the process are enormous. The testing of the DNA evidence in the kit can identify an unknown perpetrator. It can confirm the presence of a known assailant, and it can corroborate the victim's account of the rape. In many ways, this process gives voice to individuals who are so often silenced. Rape kit testing will certainly not solve all rape cases, but it has the ability to move many of them forward. To accomplish these things, however, the kits must be tested in a timely manner, and we have to ensure that the kits are not sitting untested on a shelf in a law enforcement office. This legislation also outlines a victim-centered process for notifying individuals who have been raped about the status of their kit. As victim advocates, we're incredibly grateful for this consideration. It's likely that notification about a survivor's rape kit status will bring to the surface strong feelings and emotions. Despite the passage of time, victims might feel as though the assault just occurred, and they can relive the trauma and fear that they experienced. Provisions for notifications that are outlined in this bill acknowledge the potential for re-traumatizing a victim and provides for a clear survivor-centered process for making that notification. While we still have much work to do to change the societal norms that allow for rape to occur in the first place, this bill addresses the current and future issue of backlogged evidence. It gives survivors the justice they deserve, and it assists in holding perpetrators accountable. We urge you to pass House Bill 528. I'll stand for questions.
Questions for the good lady? Seeing none, thank you very much for your testimony.
Thank you.
Okay, do we have anyone else? Oh, we have Matthew. You were.
Cynthia and then Matthew.
All right, go ahead. Welcome to committee, man.
Thank you.
State your name for the record.
Cynthia Cook, COOK. Mr. Chairman and members of the committee, I'm here to represent what a forensic exam entails and to tell you a little bit about that. Since 2001, within our community, we have seen 1,590 victims of sexual assault. 1,272 of these victims chose to have evidence collected. 318 chose to not have evidence collected. It's a very extensive process for these victims. The time of the exam for a victim is typically about 2.5 hours when it's a sexual assault nurse examiner doing the exam. The nurse is there for another total of 4 hours to ensure that evidence that has been collected is handled appropriately, packaged, and chain of custody maintained. So when you talk about an evidence collection and what does it contain or what is it that's about it, Matthew's going to show you what the actual box looks like, but we work with the victims. And the first part of it is that we do a forensic interview. We do an assessment of their body. We look at their body from head to toe. That includes an extensive genital assessment. We do injury photo and documentation, so we look at any injuries that are on their bodies. We take photographs of them and we document that. And of course, that includes the evidence collection. The evidence collection has to be handled carefully and chain of custody maintained. And then the last part of it is that we see to the victim's needs. We make sure that they get appropriate referrals and discharge instructions. Thank you.
Questions for the good lady? Representative Kirby.
Mr. Chairman, ma'am, so out of those 1,272 that were the evidence that you did collect, how many of those were analyzed?
I'm not able to answer that question. At the time that we complete the kit, we sign it over to law enforcement or place it in an evidence locker. After that, I'm not aware of what follows.
Okay, seeing nothing further, thank you very much for your testimony. Matthew, welcome to the committee. Time's yours.
Thank you, Mr. Chairman, and thank you to the members of the committee for the opportunity to be with you again. I wanted to spend a few minutes and talk to you about the state lab. My name is Matthew Gammon, and I'm the lab system director for the Idaho State Police Forensic Services Labs. We are the labs in the state of Idaho that process all of the DNA evidence in any case in Idaho. So all of that comes to our facility in Meridian. I do have with me a sexual assault kit. This is what it looks like. That's what's collected. Inside there, there's envelopes, there's swabs and other things. And I'll allow the page to come and grab it and maybe circulate it so that you can look at it. This is a brand new one, so no concerns about biologicals or anything like that. This is a brand new kit, but you're welcome to open it and take a look at what's inside. So I wanted to run you through a little bit about the process, just so you understand. We at the Idaho State Police Forensic Services work with the manufacturers to identify the proper swabs and other things that need to be in that kit. We then procure those through state procurement processes. We then send them out to hospitals and clinics around the state. There is no cost to the victim. There is no cost to the hospital. We absorb that cost into the ISP budget, and that is part of the fiscal note behind this bill. Now, there is currently no tracking mechanism when those kits leave our lab. So we send them out. We send them out to places where we're accounting for how many kits we send them, but we're not accounting for them beyond that process. There is, in the new kits, there will be a serial number associated with the kits, but the current kits do not have a serial number or any tracking mechanism on them. We've fixed that with the new order in apprehension of something going forward in the near future. So I want to be very clear that Idaho State Police Forensic Services does not oversee this process at this point. Once it leaves the hospital and goes to law enforcement, we as forensic services, as a laboratory, we don't store evidence. They are not our kits. Those kits go to law enforcement, and they are ultimately accountable for the final disposition of those kits and the final handling. We test what gets submitted to us. So if it comes in from law enforcement, it gets tested. We do have criteria for those kits to come in. I'll talk more about that in a second, but if it comes to us, it gets tested. Once we do some screening of it, do the DNA testing of anything that may be there, any biological material that may be there, it then goes, if there's a qualifying profile that we develop from that, it goes into the CODIS database to be searched against profiles across the country. So that's the process that we have, and then it goes back to law enforcement for storage, prosecution of the case potentially, and then final disposition of that kit. I wanted to run you through kit submissions. We had 93 sexual assault kits come into the laboratory in the calendar year 2014. We had 128 kits come in the calendar year 2015, which is about a 28% increase year to year. We do anticipate that continuing to increase as there's more visibility to this issue. Based on some of the Foresight data, we're part of West Virginia University Foresight data. An average DNA analyst can work about 59 DNA cases in a year. So that's what our projections are based on. There is a cost to processing a kit. If you look at the total cost, facilities, analysts, all those kind of things, it's about $3,000 to process a kit per kit. If you look at just the reagents and kit costs and things like that, it's about $500 a kit. So that's why we quote the $3,000 a kit, but it depends on how you're breaking out that number. Current staffing and turnaround times right now, they're available on our website. They always are available on our website. You can call it up right now. But it's about 213 days for us to process the average DNA case. It's about 7 months for those of you who are keeping track. And that would be a non-priority DNA case. So priority cases go to the top of the stack. Speedy trial things go to the top of the stack. We're just constantly moving that to meet the needs of the court. There are 113 DNA cases today, over 30 days in our laboratory. We have 3 staff, 1 supervisor, and he's also the technical leader, and so most of his duties are not casework. So we have the equivalent of 3.25 full-time positions working on DNA evidence on a daily basis. I wanted to clarify that the DNA casework side of our operation is very different than the DNA database side of our operations. Distinctly different. So when you're thinking about legislation that I've been here before on, and we're talking about convicted felon samples, those go into the DNA database. The DNA casework side, that's when a sexual assault kit comes in or a homicide evidence, something like that, that gets worked in that track and possibly gets entered into the database, or the probative evidence gets entered into the database to be searched against the other side of the house. Hopefully that makes sense. So in that process, I wanted to talk about the turnaround times there because that's kind of become, I think, mixed. We do not have a backlog of DNA database samples. Those samples are flowing into the database. We have over 35,000 samples in the database. No problems. They're coming in. They're getting work. They're going in. We do have, right now, what I would consider a significant backlog in DNA casework. The reason for that, there's many reasons for that, but we're training a lot of analysts to fill positions at the state lab. There is a request in the fiscal note for 2 new DNA analysts. It takes us about 6 months to a year to train a new DNA analyst, so I want to be clear that we're not going to solve this issue on day 1, even if we get the positions. It's going to take some lag time to get those people trained, get them up to full speed, and clear the backlog that we have right now. Now, I would say, as in the nation, our backlog is not considered significant. There are labs that have significantly larger turnaround times than what we have, and ours has been lower. But right now, our strategic goal is to be under 60 days. That's what we're staffed for, to be under 60 days to process a DNA case through. Anything shorter than that, if we want a 30-day turnaround time, that's just going to take more staff and more resources to do. And that's why the fiscal note for this bill includes more staff to bring those turnaround times down. That's at the request of the prosecutors and also of the Supreme Court of the state. They've met and they've talked to me, and they're interested in seeing all DNA cases be worked in less than 30 days. That's to expedite their process. We're eager to help them meet that need. So this would go to solving more than just the sexual assault backlog or sexual assault kits coming into the lab, but it would also address some of the other things like homicides and assaults and other things. We want all the turnaround times to be under 30 days. So I want to talk to you about the unsubmitted kits. You've heard a lot about it in the media, so I want to clear up some of the confusion out there. I became aware of this issue about 2013, 2014. You're aware of some of the things going on in Houston, Los Angeles, Detroit, some of the other big cities that had these issues in the media first. We started to address this issue in June of 2014 here in the state of Idaho, and we circulated a survey to all law enforcement June 27th of 2014 to ask them, how many kits do you have sitting on your shelves? Again, ISP is not an oversight body or oversight law enforcement agency for county and city agencies. That's not our role. So it's voluntary if they chose to respond to us. We wanted to know the data, but it's not mandatory that they responded. We also set up a committee that was mentioned by the representative. Law enforcement, Supreme Court, prosecutors, a public defender, multiple victim advocate groups, SANE nurses, forensic nurse examiners, hospitals and clinic administrators, a medical doctor, lab management, scientific staff, including our CODIS administrator, Idaho Victim Compensation Fund, and finally you heard that we had the legislator come. Thank you, Representative Wintrow, for coming. So policy was developed at these meetings, and we set a policy that we felt like everybody could live with or everybody weighed in on, and that was that there were two exceptions from a kit coming into the state lab. One is when the victim said, don't process my kit or don't proceed with my investigation. And the other one was when law enforcement had determined that there was no crime committed in the case. So what we determined is we can't, as a crime lab, accept kits into the lab if there's no crime. There's no evidence of a crime, or law enforcement has determined that there was no crime committed. So we told them specifically, don't send the kits on those two types of cases, but research everything else and send it in. What we found is that law enforcement was doing a pretty good job of submitting things in, but they weren't submitting one type of case, and that was cases where identity was not an issue. So if it was kind of a he said, she said type situation, they weren't sending that kit because the identity of the perpetrator or potential perpetrator was not an issue. They didn't feel like they needed the DNA science. We provided some education that those cases would still go into the DNA database if there was a crime committed, and that they could potentially be linked to other cases. So those kits started to flow into the lab, and we gave that direction to law enforcement. We had multiple communications. In fact, we sent out 4 different communications to law enforcement, chiefs, sheriffs. We educated at conferences and other things. We met with individual chiefs and sheriffs to tell them to submit these kits in. So we found out a number of how many kits were out there, and we started to proactively address that. We found money through the National Institute of Justice and the FBI lab to get these cases worked in an expedited manner for Idaho. So we started to submit them in as soon as the detectives could tell us that they were ready to go to the FBI lab. We wanted to get these quickly addressed and also into CODIS. So here are the numbers for that project for your benefit. 175 is the number of kits worked by the FBI lab on behalf of Idaho agencies since September 2014. These were sent directly from the agencies. We coordinated with the FBI, but they were sent directly by the agencies. There are 90 more kits currently waiting in the FBI queue that have shipping dates to go to the FBI laboratory in the next few months. We anticipate that by July that we will have addressed all of the previously unsubmitted kits. We did work some of those kits in state, but we decided to send most of them out because the FBI was willing and because we wanted to focus on some of the other cases that were coming in and address those with our resources that we have. So because of federal spending and the FBI assistance, there were 265, or there will be 265 unsubmitted Idaho sexual assault kits that will be worked through this process. And we currently are not aware of any kits in Idaho that are sitting on shelves that, that do not fit into those two criteria that I described. So there may be kits sitting on Idaho law enforcement shelves that fit those two criteria that I described, where the victim has said, don't send my kit, or law enforcement has said, there's no crime. So those kits could still exist. But all of the other ones that we're aware of have been addressed. I want to talk briefly about what this bill does. It provides for us to do the processing in 90 days, and that's a safeguard. So what we would do is we would set it at 30 days. That's what we're striving for. And then it gives me 90 days in case we have instrument issues, staffing issues, things like that. Then we can have that little bit of a buffer. But at 90 days, I would owe you a report and the county prosecutor a report of why those kits are languishing in the lab and not being processed. It does require that 90-day report. That allows you to know that we have resource needs or there's something else going on at the state lab. It allows by state statute for us to talk to the law enforcement agencies and direct that those kits be submitted, and it also allows us to collect the data and generate the report. It allows us to promulgate rules for the stakeholders, with the stakeholders, for the best tracking processes. That's something that's lacking right now. Again, we send them out, but we don't track them after that point, so I can't give you great data on what was out there. I can tell you how many kits we identified in our survey, but again, it was a voluntary survey. It also provides a transparent public report on our website so that this problem doesn't happen again. I think I've addressed most of the things in the fiscal note. Again, it's 2 scientists, salary and benefits for those 2 scientists. It's 1 person at what we call a forensic evidence specialist level, and that person would be doing the kit tracking, so sending out the kits, making sure that they come back into the laboratory, making sure that the ones that are on law enforcement shelves meet the 2 criteria if they're not getting submitted, and generating reports. And then also the cost of the kits themselves. So the fiscal, as you can see, is the $222,300 for the first year. There are some capital needs there for scientists to get them going, and there's some ongoing training needs for the scientists. So the annual ongoing would be the $207,300. With that, representatives and chairman, I would stand for any questions you have.
Questions for the good gentleman? Seeing none, thank you very much for your testimony. Is there anyone else out there that wishes to testify for this bill or against? Okay, would you wish to wrap up, Representative?
I don't think I have to say much more, Mr. Chair and committee members. I think they all did a great job, and a special thank you to Matthew Gamet, because you can see he's taken initiative in our state to do all he can, and so does the Idaho State Police, to try to collect all this information, but there's just no statute. He can't make people do that, as he kind of said to me one time. So I think that's our responsibility, is to create the systems. They're systems that everybody agrees to, and I think it's an important move in our state to assist victims of crime and hold perpetrators accountable, and I think create some better efficiencies and transparency. And I really emphasize the need for that fiscal note is really important if we're going to do it right. And I think we owe that to our citizens in our state.
Thank you, Representative. Just one question. Perhaps it was when I was out of the room, but did you or can you tell me if JFAC has been consulted and if this money has been set aside for that?
Mr. Chair, I have consulted with the 2 co-chairs to let them know this bill is coming. They have made no promises, but they were both very supportive and encouraged to have a very accurate fiscal note on. I don't want to put any words in their mouth, but they felt very supportive to me in making sure it was an accurate fiscal note.
Representative Kirby.
For motion,
Motion's in order.
Mr. Chairman, I move that we send House Bill 528 to the floor with a due pass.
You've heard that motion. Discussion on that motion. Seeing none, all those in favor signify by. Aye. Any opposed? Okay, motion carries. Thank you.